The next argument is Terrence E. Babb, MD versus Geisinger Clinic. Representing Geisinger Clinic is Mr. Douglas J. Smiley. Representing Dr. Babb is Mr. Andrew W. Barbin.
Good afternoon. In Pennsylvania employment law, there is a longstanding presumption that employment is at will, or that an employee can be terminated at any time without any particular reason. This presumption can be rebutted, however, or overcome, where it can be demonstrated that a contract was intended for a definite period. The issue in this case centers on the standard of proof, namely whether one seeking to overcome the presumption of at-will employment can prevail under the general civil standard of a preponderance of the evidence, or if there's a higher threshold of proof by clear and direct evidence. Mr. Smiley.
Thank you, Your Honor. Good afternoon. May it please the court. I am Douglas Smiley. I represent the appellant petitioner, Geisinger Clinic, in this matter. Your Honors, based on Geisinger's contract with Dr. Babb, he was an at-will employee who could be terminated with or without cause. In fact, his agreement specifically referenced termination for or without cause. The fact that he was given an opportunity for review of the underlying circumstances did not change the fundamental nature of the employment relationship. At the time this case was tried, the only claim at issue was for breach of contract. Although the contract was one for employment, the Superior Court had stated that this was not a wrongful termination case. The primary question at trial was whether Dr. Babb was an at-will employee. Under well-established Pennsylvania law, if Dr. Babb was an at-will employee, his employment could be terminated with or without cause, and the termination would not be subject to judicial review. In order to remove himself from the category of at-will, Dr. Babb had the burden to rebut the presumption by establishing one of four recognized exceptions by clear and direct evidence. Whether an exception applies, and if so, which one, is critical in terms of recoverable damages. Here, Dr. Babb disclaimed three of the exceptions and relied solely on employment for a specific duration. In order to avoid the effect of Pennsylvania law on his claim and a potential non-suit, Dr. Babb argued that he had established employment for a 2-year period. We submit if that were the case, then his damages would equal 2 years' compensation. Dr. Babb also argued that he was not given an opportunity to review the circumstances surrounding his termination. An opportunity for pre-termination review is not a recognized exception to the at-will doctrine. If lack of an opportunity for pre-termination review is the alleged breach, then in order to recover damages under a contract theory, Dr. Babb would have to prove a loss resulting from that breach. In other words, he would need to prove that had he received such a review, the result would have been different. This means that he would have had to show that the review was for purposes of deciding the merits of the decision with an ability to reverse it. There's no evidence in this record consistent with that suggestion, and in fact, his agreement stated to the contrary. He could be terminated for or without cause. What Dr. Babb was really arguing, and without any legal support, is that his employment was not at will because he had a provision that provided for pre-termination review, whether for or without cause. None of the documents comprising Dr. Babb's employment agreement specified the duration of Dr. Babb's employment. Moreover, although the practice agreement provided an opportunity for review of the underlying circumstances, none of the documents in evidence specified the manner in which such prior review would be given. The concept of at-will plus is not recognized under law. Rather, all employment is presumed to be at will unless it fits into one of the four recognized exceptions. Where a plaintiff argues breach of an employment contract and seeks judicial review, the plaintiff must articulate an exception and then prove that exception by evidence that is clear and direct. Dr. Babb did not do so. We submit that the trial court could and should have granted Geisinger's motion for a non-suit, motion for a directed verdict, and motion for judgment notwithstanding the verdict on this ground.
Mr. Smiley?
Yes.
Justice Baer, seems to be a lot of inconsistencies in what you're saying respectfully. And this is a long, complicated case, and we have limited time to get into a record prior to oral argument. This case went to trial, vigorous trial. wasn't the issue that's submitted to the jury whether there was an employment agreement or not?
The issue, well, there were three questions submitted to the jury, Justice Baer, and one of those questions was Dr. Babb an at-will employee or not.
And his defense, and you've pointed out several times, is there was an agreement for a definite duration of 2 years. There was a prior agreement, then they signed him to a new agreement, his position, signed him to a new agreement, and I think 15 days later fired him, but that he had a new agreement for 2 years. And that's what he argued. Is that, I'm asking, was that what he argued to the jury?
That was one of the things that he argued to the jury, Justice Baer.
And if he argued that to the jury and you lost that issue at the jury, isn't that this case?
No,
In other words, I don't know that this case is about at-will employment per se. This is a question to a jury as to whether or not an agreement for definite duration existed. And the jury decided that adversely to you. And I don't know that we care about the damages. Juries do weird things with damages. We all know that.
well, respectfully, we do care about the damages, Your Honor, because we have a significant body of law that talks about when employment is for a specific duration and there's a breach by the employer of that agreement, then the employee's damages are limited to the remaining term of the agreement, not some windfall amount. I mean, really, it's a contract claim. It's not a tort claim. The damages that are awarded by the jury have to flow from the breach. If the breach was a premature termination of a 2-year contract, then the damages should have been limited to the 2 years.
Let me interrupt you. I think I got you off track. Remember that we're a court of a specific jurisdiction. We granted on a specific issue. So why don't I get you back on track a little bit? What I'm interested in is whether or not what this case was about, as tried to the jury, was whether there was an agreement of definite duration. And that question went to the jury and you didn't prevail. And that's the end of the case. And the idea of at-will employment is a little bit subsumed therein because that's an exception to it. That's where I don't quite, I see a disconnect in your case, and I'd like you to explain it to me.
Well, yes, Your Honor. I see the overarching principle at play here that all employment is presumed to be at will, and the employer is entitled to the benefit of that presumption going into the case. Now, if the employee wants to argue that employment was not at will, then the employee bears the burden of proving one of the exceptions, in this case, duration, specific term. They also bear the burden to prove that by evidence that is clear and direct. And my basis for that statement is the case law cited at length in our brief, because the courts have been reluctant to open the door to have every person who contends that they were wrongfully terminated in breach of an express or implied agreement get their so-called day in court for purposes of recovering damages against the employer, when the system in Pennsylvania has been that employment is presumed to be at will. So if Dr. Babb's theory of the case were that he was employed for a 2-year period, first of all, that should have been expressly stated, and it never was. That was an argument that arose during trial, and I would invite the court to review the record on this, really, in my view, as a means to circumvent the potential for a non-suit or a judgment in favor of the defendant, because the employment was an at-will employment agreement. It said he could be terminated with or without cause. If you can be terminated with or without cause, then how do you add on to that a 2-year term, whether it's in the agreement or not? And it wasn't in the agreement. There was no, not only was there no clear and definite evidence, there was virtually no evidence whatsoever. And I am distinguishing this from those cases where a plaintiff alleges that they had a guaranteed salary for a year, or guaranteed salary measured from year to year. That doesn't guarantee a term of employment from year to year or by a number of years. That just states how compensation is to be calculated. So in this case, there is virtually no evidence that would support a 2-year term. The only suggestion raised that term.
May I interrupt you for a second? The first agreement between these two parties, was that a definite agreement for 2 years?
No, absolutely not. That's the same agreement.
When Geisinger signs an employment agreement with a doctor that it wants to employ, and it says, this is going to last 2 years, this is your salary, these are your rights. It's just kidding.
It doesn't say this will last for 2 years. It says your salary will be X dollars per year, and this amount shall be guaranteed for 2 years. But it also says, prior to any termination initiated by Geisinger for or without cause, Dr. Babb shall have an opportunity to review the reasons therefore. Well, if he could be terminated for or without cause, he has no justified reliance upon a 2-year term.
Mr. Smiley, I'm trying, it's Justice Todd, I'm trying to understand this, as is my colleague, Justice Baer. Are you distinguishing this employment contract by suggesting that it only guarantees payment for 2 years, but they never had to actually employ him?
No. It only guarantees the methodology by which compensation is calculated. So in other words, if you stay for 2 years, we will not, after year 1, reduce your salary. But there was no express or even implied duration of 2 years.
Well, by the same token, it does not say you may work less than 2 years. I mean, the whole presumption or the whole premise of the agreement seems to be based on a 2-year term. Now, it might make some sense to me if you're saying, well, that didn't mean he had to work for us for 2 years, or that doesn't mean we couldn't have fired him within the 2 years. That just means if we did fire him, we owe him for 2 years salary, but you're not saying that.
It absolutely was not a guaranteed salary. It was the basis for the calculation of the salary. His salary was calculated on an annual basis, and the guarantee, if you want to call it that, was that it would not be reduced in the second year. But
so it's neither a guarantee of employment nor of a salary.
No.
That's a lousy agreement.
It's not a great agreement for the plaintiff. I agree. It's a weak employment agreement from the plaintiff's perspective, which is why the overarching at-will arguments come into play here. If plaintiffs want better agreements, if doctors want better agreements when they negotiate their employment, then they should say my employment shall be guaranteed for 2 years, like a professional athlete or somebody who has the negotiating leverage to get that. Geisinger wouldn't do that. Geisinger not negotiated for
Smiley,
that said termination for or without cause. So there was no guarantee. And in fact, I did want to point out that Dr. Babb was about 18 months into the first 2 years. So he had been there for a year and change before he was terminated. The renewal that came up was that his credentials were renewed, not his contract. And those are two different things.
Thank you.
No separate agreement, and that's to Justice Baer's question too. No separate agreement was entered into by the parties after the expiration or before the expiration, but of the first letter agreement. So he only had the one agreement, which was comprised of several documents, but there was no express term in that agreement. And if there was, I think it should have been cited to the court.
Mr. Smiley, can you hear me?
I can.
Hey, I had a question, if it's okay with you. This was a limited grant of aliquotter. Let's focus on that.
Yes.
And read the grant if you haven't. But you sought discretionary review. We allowed it, but we said this is the issue.
Yes.
And I'd like to hear your opinion on the issue before you sit down. Can you get the question?
Yeah, I'm familiar with the question.
Well, that's a good starting point.
Yeah.
Because, and we want to know, we're interested, at least if justice is allowed to appeal, rather than rehacking all this evidence at trial, which I personally don't give a whit about. The issue is when you're trying to rebut this presumption about will employment, need you do it by clear and direct evidence, or is the preponderance standard?
Yes.
I think I noted that the trial judge was arguing over the standard jury instruction, but he wouldn't give it. But in any event, he instructed that it was merely a preponderance of the evidence. Is that correct?
That's correct. The only instruction given as to the burden of proof was the preponderance of the evidence standard.
Well, now there's other precedent, isn't it, that says in this Commonwealth, that's the incorrect standard. Am I right or wrong?
That's absolutely correct. There's voluminous case law in this Commonwealth that says that the evidence must be clear and direct, and there are some courts that say it must be clear and precise. And that really is based
It's not a
on
preponderance.
how, I'm sorry.
It's not a preponderance.
No, it's a higher standard. It's a higher standard for a number of reasons, including the importance of the at-will doctrine within the Commonwealth of Pennsylvania, but also because, and one of the policy arguments that's been recognized by the courts is, again, not opening the floodgates to claims where an employee has a belief, an employee has a suggestion, an employee has a wish that their employment was guaranteed for a specific term, but rather they must demonstrate clear and direct or clear and precise evidence. And it's easy to understand that in the context of this particular exception, which is specific duration. If you want to contend as a plaintiff employee in this Commonwealth that your employment was for a guaranteed term of years, you must present the court with clear and direct evidence of that because, and again, this case law has evolved over time, but there were cases that came about where an employee argued guaranteed employment for life, but there were other guarantees of employment for a period for a term, and the courts have uniformly held that the presumption of at-will employment is a strong presumption. And I ask rhetorically, because I know I'm not allowed to ask questions of the court, what does it mean when a presumption is a strong presumption? Well, to me, as a practitioner, as a lawyer, that means I must have strong evidence to rebut that strong presumption. I can't just introduce my own testimony as to what I believe. I can't just come in with something that says, if you work here for 2 years, your compensation shall be. I need to show that I was guaranteed a term of years.
All right, counsel, can I ask you a question on that?
Yes, absolutely.
On page 313A of the reproduced record, in your proposed points for charge, you talk about clear and convincing evidence, and on page 1011A of the record, in the transcript of the charge conference with the judge, you withdrew your request on clear and convincing. I guess when opposing counsel pointed out that's incorrect. And the judge heard some more discussion of an inconclusive nature and then said, I can't spend any more time on this. You can get back to me tomorrow. And then it doesn't appear to me that anybody did, although you can correct me if I'm wrong on that. Mr. Barbin maintains in his brief you waived this. Wasn't it your obligation to tie this up neatly and submit a point for charge that actually said, a discrete point for charge that said clear and definite, and then not avoid waiving it in your recorded remarks at the charge conference?
Your Honor, you understand the clarification correctly, that during the charging conference, the point for charge we had submitted may have said clear and convincing, and the correct standard is clear and direct evidence. And I corrected myself before the judge, but I never relented in saying that that charge shouldn't be given in some format that clearly conveys to the jury that the plaintiff has the burden of overcoming the presumption, and the plaintiff has the burden of overcoming the presumption by clear and direct evidence.
Yeah, maybe I've missed it, but just follow up. You say on 1011A, you say, so I withdraw the clear and convincing evidence instruction request because I was thinking something differently at the time. And then I searched to see if you came back to the issue and said, but Your Honor, I want the clear and definite. And I didn't find that. And so I'll give you one more chance to address Mr. Barbin's waiver point.
If I had a citation to that in the record, I would bring that up, Your Honor. My understanding at the time of the charging conference was that Judge Ruest had ruled and essentially said, I can't hear any more on this. I've decided what I'm going to do. She told us the charge she was going to give, and it wasn't the charge we had requested. But I would mention that I made this same argument before this case went to the jury when I made a motion for non-suit, in which the trial court, acting as a gatekeeper, can determine as a matter of law whether the plaintiff has met the burden of adducing clear and direct evidence to overcome the presumption. And I think in a lot of these cases, at preliminary objections, at summary judgment, and ultimately possibly at non-suit, judges need to make that determination as to whether the case proffered by the plaintiff has met the rigorous standard of evidence to overcome the presumption of at-will employment, as opposed to letting it go to a jury at the end of the day and let them figure something out as a question of a matter of law, really, as to whether an employee is or is not at will. So I raised that argument not only in jury charges, but I think the jury charge is deficient, and I think the jury charge should be clarified. I think Pennsylvania law should be clarified, and I welcome and I appreciate the opportunity this court has granted to do that, because I think clear and direct evidence should be part of the jury instruction. And the standard jury instructions as written are woefully deficient in that regard. It doesn't make clear that the presumption exists and that it's the employee's burden to overcome it. In fact, the instruction as given said that unless the plaintiff proves the termination violated an employment agreement, and frankly, as a lawyer, that's just wrong. I mean, violating an employment agreement, could mean anything. What we're talking about is, do you fit within one of the 4 recognized exceptions? Is there a just cause only provision? Is there a specific duration? Was there a violation of public policy? Did the employee provide some additional consideration that takes them out of the area of at will? So I raised that argument multiple times during this trial. I did it at non-suit. I did it for a directed verdict. I did it for just judgment notwithstanding the verdict, as well as submitting a written jury instruction that the trial judge declined to give.
Okay. Well, we'll hear from Mr. Barber.
Thank you, Mr. Chief Justice, Justices. I have prepared remarks that should take 4 minutes and 30 seconds, and I'll answer any questions, but I think I have anticipated most of the questions in my remarks. Almost 24 years ago, on May 16th, 1997, Dr. Babb was blindsided and given a choice of resigning and abandoning his patients, one of whom was in active labor, or facing the wrath and raw power of Geisinger Clinic without any specific basis for termination provided. He chose to fight for his patients. It's been a long road, and we're here after a unanimous jury verdict in his favor. One question is presented with 2 aspects. What is the burden of proof in an at-will employment case, and did the trial court instruct the jury sufficiently? Contrary to the representation of Mr. Smiley, for more than 100 years, the burden of proof on the question has been by preponderance of evidence. The issue here arises from certain arguably competing evidentiary principles with regard to the construction of contracts. The ultimate litmus has always been recognized as the intent of the parties. However, it is also agreed that a court may not supply terms not provided under the guise of interpretation. President Judge Emeritus Coriel Stevens, formerly an Associate Justice, correctly explained the analytical process applying this court's decisions in Lubrick, Price, Slonaker, Ross-Massler, Noel, and Weidman. The gist of these cases is that taken together is that intention with regard to contract is derived from the totality of circumstance and that the burden is preponderance of the evidence. The defendant seeks to limit a totality of circumstances process by codifying 4 exceptions as exclusive and thereby circumventing the totality of circumstances analysis set forth in each of the Supreme Court's prior precedent. With regard to the lower courts, in Rutherford, the Superior Court said the clearest manner in which a party can overcome the at-will doctrine is where the employer and the employee have entered into contract which expresses or implies a definite term of employment and forbids discharge in absence of either just cause or without first utilizing an internal dispute resolution mechanism. In Carlson, the Third Circuit said that a notice provision of the type here was antithetical to the nature of at-will employment. It's also appropriate to reference this court's recent decision in Rulex involving the non-compete agreement, in which the court applied a totality of circumstance, preponderance of evidence standard to a similar employment issue. Here, the defendant seeks to impugn President Judge Ruest for its own errors. They were required to provide written proposed instructions in advance. The court made its preference for standard instructions clear. The plaintiff agreed and dropped non-standard requests. The defendant had proposed a specific, clear and convincing evidence instruction, but unequivocally withdrew it. No clear and direct charge was ever submitted, orally or in writing. The phrase was merely mentioned in argument and never specifically requested in any articulated form of instruction. In addition, once the court addressed the argument, no objection was preserved. After the charge was given, no objection was preserved. The jury reached a unanimous verdict using the jury slip defendant drafted, which did not have, if you look at the jury slip, all the other provisions say preponderance of the evidence. The defendant issued a slip. I'm looking at it on the wall. It says, was plaintiff Dr. Terrence Babb an at-will employee? Check 1. I didn't write that. My client didn't write that. Mr. Smiley wrote that, or someone working with him. The evidence was more than sufficient under any standard. There was ample evidence of a contract for a specific term. There was evidence, and if you look at the renewal, he just misrepresented it again. Dr. Babb testified, Mrs. Babb testified, and the expert witness testified that it was not a renewal of privileges at the hospital. It was a renewal of his contract with the clinic. That was the testimony. That was for the fact finder to decide. The other thing, Mr. Smiley, is left out entirely, is that he just argued to you that this court should impose a higher standard. It should impose a higher standard, and it should be administered at preliminary objections, summary judgment, and non-suit. This is the only point on which we agree, with the exception of the standard. The court previously, in 2015, the Superior Court specifically addressed the grant of summary judgment and specifically found that the evidence adduced, read in the light most favorable to my client, was sufficient to establish a question of fact for the jury on the issue of at will. As far as I'm concerned, the court could have read that opinion as its instruction, left the issue to the jury, and we wouldn't have had any of the smoke and mirrors. The other major point with regard to the heightened burdens is that when they use things like clear and direct, and they use phrases like that, they're hearkening back to essentially Venetian blind. They're hearkening back to the idea that you don't put into a contract something that wasn't there. But Mr. Justice Baer, I totally agree with you. Based on his interpretation, and this was in the closing arguments, I basically took up the board where it had with or without cause, and I circled those 4 words. But they were embedded in a full paragraph, and he was ignoring 17 words before and 34 words after. I could have the word count wrong, but he was asking the jury to ignore the duty of good faith and fair dealing and basically recognize an ambiguous trap door.
Counsel.
That's fine. Thank you, Your Honor. I appreciate your patience.
Counsel, Justice Baer, can you hear me?
Yes.
Okay. That was impassioned, but I see the case a little simpler. I haven't lived with it for 24 years. I just looked at it a couple days ago. Was the first agreement, in your view, between Babb and Geisinger a 2-year agreement?
Absolutely, with lots of other beneficial provisions that Geisinger ignores.
Okay. Was there a second agreement?
Yes.
And was it for 2 years?
Yes.
And was that what was placed before the jury?
Absolutely.
Whether there was a second agreement or not?
Absolutely. It was placed, we had a blow-up board. It was placed before the jury.
So So if I understand this correctly, Geisinger has argued vehemently in a jury trial that there was no agreement, second agreement. You argued vehemently there was, as you point out, you called an expert witness, you called your clients, etc. And evidently you had a special jury slip, which we can look at, but it says that there was an agreement. Is that right or wrong?
Basically, the jury slip, which I'm looking at, was first asked whether he was at will. Second question, by preponderance of the evidence, did they breach the contract?
What's the answer to the first question? Was he at will?
No.
Okay. That brings us down to where I think the Chief Justice was. Do you agree that if there's no contract, you don't have one of these four criteria, the first being was there a written agreement, that you're in sort of a he said, she said, who knows, that under Pennsylvania law, the party trying to overcome at will has to do it by clear and convincing?
No, actually not. If you look back at the earlier cases, and I'm specifically Weidman, which is 72 Atlantic 377 1909, and you look at Sloniker 1940, Lubrick 1956, these were not cases that were decided under some theory that there were only four ways to rebut the presumption. The original case law is very clear that it is the intention of the parties that binds, but that that we look at the totality of the circumstance. The main place where the train jumps the track is, I agree with Mr. Smiley that you can't imply terms that aren't in the contract. I think there's plenty of contract construction cases that don't apply a different standard. They simply say, we're just not going to assume things. It has to be clear. They use language like clear and precise. But that's not a different burden of proof. The burden of proof is always and only by a preponderance of the evidence, what is the discernible, reasonably discernible intent of the parties. And in many cases, like the 1919 case, which is the Noel case, in 1919, prohibition had come in, and there was essentially a requirements contract. And the guy terminated supply of requirements before the law required termination of supply. And so they said the reasonable expectations were that you weren't going to fire them. The best case is the Weidman case, the 1909 case, because what they basically had was a sale of a business. Okay? It didn't fit with any of the four exceptions that are currently being argued by the defendant. What that case involved was they were selling a business that was making a profit, but they were joining a group who had lots of other businesses like it. You can imagine that there was some kind of economy of scale, and they were given salary amounts that were reasonable salary amounts for the work that they would be doing as employees. They only received the value of stock in addition. And the court looked at that and said it wouldn't make sense for either side if they didn't intend a longer agreement, for the simple reason that if he signed the agreement, then they could fire him the next day and all he would get was the value of stock. And since his business was making money, that doesn't seem consistent with the logical intent of the parties.
Counsel.
Thank you.
Counsel, it's Justice Donahue.
Yes.
Counsel, can you hear me? Counsel, okay. I'm really frustrated by this. Let me try to get back to where the Chief Justice was. Are you in agreement with the general proposition that in Pennsylvania all employment is at will?
There is a presumption that absent other evidence, employment is at will.
I'm not asking you that question. Are you in agreement with the basic principle that in Pennsylvania all employment is at will?
Absolutely.
Okay. And in order to rebut that presumption, some quantum of evidence is required by the person who's challenging that presumption. Are we in agreement on that?
Absolutely.
Okay. So in this case, you start with the presumption that your client's employment was at will. And so then the question becomes, what is the burden to overcome that presumption? The reason we took this case is to decide whether or not that is a preponderance of the evidence or clear and convincing evidence. This court, this is a case of first impression, as I understand it, for our court as to whether or not clear and convincing evidence is required to overcome that presumption. And what is your best argument that it is not clear and convincing evidence that's required, but a preponderance of the evidence?
I believe that the court's own precedent, spanning 100 years, has always said that it's the totality of circumstance, and this court has never said it was clear and convincing evidence, nor should it.
Well,
because
why
this
not?
court,
Why
because,
should it not be a preponderance of the evidence, keeping in mind that a totality of circumstances evidentiary standard has to be met either by a preponderance of the evidence or clear and convincing evidence?
right. And my point is that this is a simple contract case. The standard is, what was the intention of the parties? That's always been the law of Pennsylvania. And we have an evidentiary. I'm sorry.
And what quantum of evidence of the totality of the circumstances, in your view, must the person challenging the presumption come forward with?
Preponderance. Anytime I argue breach of contract, I have the obligation to prove the breach. But in every other contract, my burden is preponderance of the evidence. The way I look at this, and it was how I phrased it in the brief, there is a burden of production. I am required to set forth evidence at preliminary objection, at summary judgment, at a default judgment. I'm required to present evidence from which a reasonable juror could conclude that it was neither the expression nor the intent of the parties that the relationship be at will. And I can prove that not with 4 narrow restrictions. Trying to codify the 4 restrictions into the only exceptions ignores that there are dozens of circumstances. One of the quotes from Weidman I would like to share. Basically, I'm sorry, I had the wrong case. One of the cases that I cited specifically says, precedents aren't worth a whole lot in these cases, as they're not worth a whole lot in trying to judge the intention in a will case, because the facts and circumstances of every case are unique. And the Superior Court in 2015, this court denied aliquotter, said the facts and circumstances we laid out were sufficient that a reasonable juror could conclude that this wasn't at will, that there was a contract and it was breached.
Mr. Barbin, if I could just chime in here. You're making arguments that, in my view, are not responsive to the question posed by Justice Donoghue and the question that we're all trying to grapple with today, and that is that issue of first impression that we accepted aliquotter on with respect to the burden of proof. Now, you keep referring to, all of the evidence and all of the totality of the circumstances and what's in the contract and what's not in the contract, and that all goes into a finding. But what we're focused on is the burden of proof. So if you could just sum up, basically addressing only that issue.
Thank you. The point I am trying to make is that there is no special reason for an additional burden. This is very much like the trial court makes an additional determination as to what a contract is capable of meaning. If there are factual disputes, then the jury decides what they believe the true intent of the parties is. It is not necessary, nor it is appropriate to say that in order for the totality of the circumstances to rebut the presumption, there has to be something more than the simple standard of, is there evidence from which a reasonable juror could believe that the intent of the parties was that there be some other contract other than at will. And I do want to note two last points. They did not attempt to use at will at the time of termination. They used both for-cause procedures, both of which allowed for reinstatement. This was not a circumstance where it was at will only. There was evidence of a definite term, and there was evidence of a review process that could result in reinstatement. These kind of circumstances illustrate my point that when there is sufficient evidence from which a juror could find that at will was not intended, as the Superior Court did in 2015, then it is an issue for the jury on preponderance, and a special burden no longer applies because there has already been a determination that there is sufficient evidence from which a reasonable person could believe the contract did not intend or envision at-will employment. I will also note that former Justice Stevens specifically ruled that their with or without cause argument had actually been waived as well, which I noted in the brief.
Could I jump
Thank
in
you.
on that? Pardon me, Chief. Could I just jump in on
Yeah.
that last point?
Yeah.
Briefly, I want to give you a chance to address that waiver point that I asked Mr. Smiley about. I've been looking through the record, and I have not found anything to shake my earlier impression that Geisinger withdrew that clear and convincing language without replacing it with a specific request for a clear and direct instruction thereafter. Am I correct?
Absolutely and unequivocally.
So if the Rules Committee should propose a new standard instruction, that's something that we could consider prospectively, but there's nothing before us here. Isn't that right?
That is my point.
Thank you. Thanks to both counsel. We'll take our usual break and then continue with the argument list.
Thank you.
The next argument is in the interest of TW, a minor. Representing TW is Mr. Victor Rausch. Representing the Commonwealth is Mr. Daniel Casulo.
Good afternoon. This criminal case involves a challenge to the denial of a motion to suppress evidence and requires the court's clarification as to when police officers may conduct an additional, a more intrusive search of a pocket following a pat-down for weapons. Mr. Rausch.
Thank you, Your Honor. May it please the court. When the Supreme Court, the U.S. Supreme Court in Terry, held that police could pat down the outer clothing of a person based on less than probable cause, they made it absolutely clear that this was a tightly limited exception to the normal requirements for a search. The approach taken by the Superior Court and urged by the Commonwealth in this case would turn that on its head, and the exception would end up swallowing the rule. The Commonwealth says that the police officer should be able to escalate a frisk into a more intrusive search unless a lack of a weapon is proven. This is the exact opposite of what the Fourth Amendment requires. Instead of each intrusion requiring an additional justification, here the intrusion will be presumed justified unless shown otherwise. This approach can't be squared with Terry, and it certainly can't be squared with Ibarra or Dickerson or any of this court's binding precedents. Those cases all reaffirm that the baseline for a search, a full search of someone's person, a search under someone's clothes, or in this case here, in someone's pockets, requires probable cause. The Superior Court in this case, and this court's non-binding plurality opinion in Taylor, are in conflict with those precedents. Here, it's clear the officer did not have probable cause to believe that TW had a weapon in his pocket or other contraband. The officer admitted many times that he felt an object and he had no idea what it was. He admitted on cross-examination that it was not shaped like a handgun.
Mr. Rausch, excuse me,
Yes.
it's Justice Todd. Didn't the police officer in this case say that he was concerned it was a weapon?
He did say that, but he gave no basis for why he was concerned that it was a weapon. He did admit on cross-examination it was not shaped like a handgun, and he gave nothing else other than after saying several times, I didn't know what it was, I didn't know what it was, I was concerned that it could be a weapon. He didn't
Well,
elaborate on it any further than that.
given our concern, our obvious concern for police officer safety, it seems to me what you're asking for is simply more of an articulation by a police officer as to why he thought it might be a weapon. Is that correct?
Not exactly, Your Honor. What I'm asking for is ultimately the difference between my position and the position of the Commonwealth here is a difference in the Fourth Amendment framework. I'm arguing, and I believe the Supreme Court's cases back me up, that probable cause is the baseline requirement always for a search of someone's pockets, and there is a tiny limited exception for Terry of a pat down of the outer clothing.
Mr. Rausch, just before you go further in answering Justice Todd there, you keep harping on this Terry probable cause, but in the Adams case, the court found that probable cause was lacking and yet upheld the search that occurred after a Terry frisk. So the Terry sequence can segue into the protective search if the facts merit it. And probable cause is not required for that to be set in motion. Otherwise, the Adams result is inexplicable because the court said there was no probable cause in that case, but the search was upheld. That's a SCOTUS case.
Yes, Your Honor. I don't think, with all due respect, sir, I don't think that's in line with Ibarra or that's in line with Dickerson, which makes it very clear, in particular, in both Ibarra and Dickerson, that probable cause is the baseline. And Dickerson, which is the main plain field case, that's the entire basis, that's the entire rationale there, that, once the pat down was done and then the officer did essentially have probable cause by being able to tell through the feeling on the outer side of the pockets that there was contraband inside, was then able to search. I can't recall the exact facts of Adams off the top of my head, I'm afraid, but I don't think that Adams is out of line with those cases.
But doesn't the plain, excuse me, Mr. Rauch, this is Justice Mundy, doesn't the plain field doctrine not applicable to the Terry line of cases, which is about officer safety?
Well, thank you for the question, Justice Money, because that's the crux of the disagreement. I don't think the Commonwealth is trying to claim that there are two separate lines of cases, and I don't think that's the case. The Supreme Court in Terry and, again, in Ibarra and Dickerson made it clear that Terry is not outside of the regular framework of Fourth Amendment cases. So my answer to your question is I don't think there's a separate line of cases with a separate justification under Terry. That's exactly what I'm arguing against. Terry allows only what it says it allows, and what the Supreme Court has always made clear is a very tightly cabined exception of allowing just the pat down of the outer clothing. Anything further requires a further justification. And
so, counsel, I'm sorry, Justice Doherty. So, from your logical perspective, the officer being honest on the stand shares with the judge that he's not sure what it is, but he reasonably believes it's a weapon. And despite the fact it's not shaped like a gun, a weapon can come in a variety of types. What is it that you think he should have done? Just allowed him to go off by himself? Or should he have been detained and sat in a police car in handcuffs waiting for a probable cause warrant? What is it that you're asking us? Because in essence, the way I truly see the application here, you're asking us to say the fact that the moment he said these magical words, I don't know, therefore now every officer is excluded from going into the pocket in further search of or protection for their safety. If you say magical words have to be done, now we will have officers trained as to these magical words. So in order to have a truly applicable procedure, I fall back to my original question of you. What is it that you thought the officer should have done in your scenario?
I have two parts. Thank you for the question. I have two parts to my answer. First and foremost, the question is not so much magic words here, but facts that would support the required level of justification for the search. That's the case in any either Terry stop or excuse me, or any search where probable cause has to be articulated. The officer articulates, or whoever's testifying on the stand in a motion articulates the facts, and then it is up to the judge and whether or not they're enough, not about magic words or what the officer suspects. So that's the first part of my answer. The second part is
with all due respect, that doesn't answer the first part. We're talking, once again, magic words. You're saying that we should listen to what was said. So in reality, the officer had one of two options. I believed it was a gun or a weapon, or when I patted it down, I'm now jumping to a Dickerson analysis and saying, oh, what I felt I knew to be contraband. Either way, magical words. I knew it was contraband or I believed it was a weapon. And what I'm saying to you in this particular case with a honest officer, where do we go? What is it that the officer was have done to TW?
Well, firstly, there's always a problem that the officers may not be necessarily be honest, and I'm not claiming the officer was not honest here at all, but they can always try to add more facts, and the trial judge has to make a credibility determination under those circumstances. As far as what the officer should have done here, he felt outside my client's clothing. He didn't feel anything that he thought was a weapon, and that was that. What I'm saying he should have done is continued on with the rest of the investigation of the traffic stop. My client was a backseat passenger. I'm not going to get into all the details of the fact, but he should have continued on with everything else he was doing.
Just a minute, Mr. Rush. I hate to interrupt you, but that's not what the officer said. The officer said he had a concern that it might be a weapon. Isn't that right?
I don't have the notes in front of me. I know he said he did not know what it was. He said that multiple times. And then at some point he said, yeah, something like he had a concern it might be a weapon. I think that is correct, Your Honor. But he didn't give any facts as to why he thought it might be a weapon. And he acknowledged that it wasn't shaped like a handgun. And he didn't back up he didn't give anything to back up other than the mere words, I was concerned there was a weapon. And this ties in actually to my answer to Justice Doherty. the task for the judge, when hearing a motion like this, is to listen to the actual facts the officer brings forward. What did it feel like? What shape was it? Et cetera, et cetera, et cetera. The burden's on the Commonwealth, in this case on the officer testifying, to put forth facts sufficient to justify the level of intrusion.
Mr. Rouse.
Mr. Rouse, my original question to you, which was, we're going to write to this, so maybe what you're looking for, although you're looking for this and they're looking for this, and maybe it's in between, but maybe what you're looking for is for us to require an articulation by the officer of the facts that gave him that concern that it was a weapon.
And I guess my response to you, Your Honor, is that we have to decide the case that's actually before us. Is it possible the officer could have put forth articulated things that would have led to sufficient probable cause to search a pocket? Absolutely. But he didn't do so in this case. We have to decide, what's on the record here, and he simply did not articulate facts sufficient to provide probable cause to search my client's pockets.
We're not just deciding for case and this question with respect to this defendant. We're deciding what the law of Pennsylvania should be and trying to provide guidance to the bench and the bar and to our police officers.
That's correct, Your Honor, and that's why I'm spending time in the brief and here at argument trying to talk about what the Fourth Amendment standard ought to be. I think that's ultimately the conflict between my position and the position of the Commonwealth here is, and this gets back to Justice Mundy's question as well, is Terry a wholly separate justification for searches that exists in a free-floating way, completely detached from all the Fourth Amendment standards, or is it a tiny exception in the greater Fourth Amendment precedent, in the greater Fourth Amendment rubric?
It's Justice Clair. I think we can end this. What you want is a matter of law that if the police officer is going to go beyond the outer layer, he has probable cause rather than reasonable suspicion. Isn't that correct?
That's exactly correct.
That's the whole case. Thank you.
Counsel, it's Justice Donahue. Terry actually holds that the search must be confined in scope to an intrusion reasonably designed to discover guns, knives, clubs, etc. Okay, so that's what Terry says. So
yes, Your Honor.
In this case, we have an officer, and nobody suggests that this is inaccurate. And prior to doing the pat down, he had a reasonable concern for his safety. So he was going to do a pat down. So he does the pat down, and in the light most favorable to the officer, he says, and you know what? After the pat down, I still had a reasonable concern for my safety because I didn't know what that hard, large object was in the pocket. Is it not a search reasonably designed to discover weapons to then reach into the pocket to see what it is? He still has the same concern for his safety that he had prior to doing the pat down. Not because he didn't feel anything, but because he felt something. So, I mean, is it really an extension of Terry to say that what's reasonably designed in that circumstance is that he has to reach into the pocket to allay his concern?
Yes, Your Honor. I believe it is an extension of Terry because Terry, the language you quote is absolutely there, but they also go on as to how part of the reason why they're basically willing to carve this exception to the previous requirement for probable cause is the very limited nature of the intrusion, not going within the outer clothing or within the pockets. And there is language in the Terry opinion very much about that.
But
this
they were
is,
lucky.
I think that...
Counsel, they were lucky. They were lucky because the officer in that case felt the gun.
That's correct.
So they didn't have to grapple with what we're grappling with here. What if that officer had said, geez, it's hard, it's large, I just don't know, I'm still concerned. I mean, is then reaching into the pocket an intrusion reasonably designed to allay his concerns for safety? I don't know the answer. I'm asking you.
Yes, Your Honor. And I think there's always a balance in these cases. There's always in some ways, the officers would be safer if they could fully search everyone that they stop, but that's not what's allowed. There is a balance, and the Terry court did, as I mentioned before, spend a lot of time on noting that, the intrusion of a pat down of the outer clothing, while significant, was far less than the intrusion of a full search of someone's inner clothing or inside their pockets. And this is an intrusion on bodily integrity, and greater intrusions require greater justifications. After patting down my client, the officer didn't really have much more than he had before patting him down. He has an object in his pockets. Everyone has objects in their pockets, and he didn't know what it was. And while he most certainly did say that he was concerned it might be a weapon, he didn't give any basis for that or any facts. His concern is not what's, in this case, relevant. It's the facts that would objectively lead to a determination that it could be a weapon. And he didn't provide any other than, I'm sorry.
That works out well because that's where you begin, so it's a good place to end. And, we're going to hear from the Commonwealth.
Good afternoon, Mr. Chief Justice, Justices of the Supreme Court. Good afternoon, Mr. Rausch. My name is Dan Casulo, arguing on behalf of the Commonwealth. So not all intrusions into a pocket are the same. The defense argument that you need probable cause to remove any object from a pocket is inconsistent with the vast body of search and seizure law, which recognizes that there is a difference between evidence gathering for non-threatening contraband and a protective search for safety. These are two different types of searches and have been and should not be subject to the same scrutiny. And so when an officer is performing a protective pat-down and is acting within that limited scope that Justice Donahue was talking about of discovering and removing weapons, then the appropriate standard to use is reasonable suspicion under Terry, not probable cause under plain field. So the question for this particular case becomes whether Officer Grant's actions were objectively reasonable, where it's 4:15 in the morning, we're in an area where there's recently violent activity, there was a high-speed car chase, there was a car crash, there was a chase on foot, there was a car stop on foot, his partner's preoccupied with the people in the front seat, and there's this person in the backseat of the car blading his body away from the officers, fidgeting in his pockets, being told not to, despite being told not to. And everything up to that point, everyone agrees, could feel something large, hard, cylindrical, and can't tell exactly what it is. Well, the simple answer is exactly what Officer Grant did. Remove that object in order to swiftly confirm or dispel the threat of weapons.
Well, wait a minute. Can I stop you there? Because you emphasized that in your brief, calling it a binary choice. And I wasn't sure that's correct. Isn't there a tertiary choice? Isn't there a manipulation that could have been done given that Officer Grant presumably truthfully told the court he didn't know. In other words, he didn't lie and try to improve on the record. He candidly said, I didn't know. So he arguably he was lacking what he needed to rummage through the pocket. So at least at that point, why wouldn't the court's proper answer to be here to manipulate the manipulation from outside the pocket following the inconclusive Terry frisk would have presumably revealed that this was not a weapon, that this was a pill bottle or medication bottle? Why isn't that third thing a possibility here?
That's a great question, and I think there's 2 points to my answer. The first is that manipulation kind of has this bad rap after Dickerson because the officer manipulated it, and because of that manipulation, the court said, well, you're beyond Terry now because you're manipulating it, so there's that problem. But also, the question isn't whether the officer could have done baby steps of minimally more intrusive act and to pull that object out if it was a weapon. Probably. So we're looking at what actually happened because it's the totality of the circumstances. It's practical. We have to take into consideration the practicalities of these stops.
Counsel, it's Justice Donahue again, and back to Justice Weck's point. And I'm going to, again, get back to Terry itself, which talks about a search confined in scope. Manipulation in this context was the next step, not reaching into the defendant's pocket. That would be, in fact, reasonably designed, actually, to confirm what the officer first said to describe what he felt in the pocket, which was something that was about the size of a cough syrup bottle. And lo and behold, that's what it was. A manipulation at that juncture would have confirmed, which frankly, is what he thought it was in the first instance, or had reason to think it was in the first instance.
So if I could just clarify the record based off of your question real quick. He described it as a cough syrup bottle in hindsight. I have the transcripts right in front of me. When he was asked, what, if anything, did you feel during the open-handed pat-down? It was simply, I felt a large object in the left pants pocket, and what did you think it was? I wasn't sure what it was, but it was large, so I felt the need to take it out. Was it hard or soft? Hard. And you didn't know what it was? No, I did not. So I don't think the record shows that he thought it was a cough bottle syrup. I think the record shows that he really did not know what this was. And again, could he have tried to manipulate it and that would have been the next reasonable step? Maybe, but the question isn't whether that would have been objectively reasonable, but what he actually did was objectively reasonable. Given the totality.
Let's probe that for a moment. Why is it that which would be objectively reasonable under the circumstances? I mean, why is it not objectively reasonable to take the next least most intrusive method to determine what it was, which would be to manipulate that hard object that was in the pocket?
So again, I have 2 points to the question. First, again, it would have been objectively reasonable, but for this case, it's whether pulling it out was also objectively reasonable. And we have to consider, would fiddling around in the pocket just cause the situation to become more dangerous if that is giving defendant time to use this potentially dangerous object? These are the standard is what an objectively reasonable officer would do in that situation, not what we would do in hindsight when we're able to calmly evaluate it. I think that is why, would it have been objectively reasonable for him to manipulate it? Yes. But for this question is whether it was objectively reasonable for him to take it out. I think the answer is still yes.
Counsel, you're correct on objective reasonableness, but it seems to me you're skipping over Justice Donahue's point about the Terry command for least intrusive means. So when you responded to Justice Donahue by saying it would have been objectively reasonable to do what he did, it would have also been objectively reasonable to manipulate, then when you add in Terry's requirement for least intrusive means, don't you default to that manipulation first?
Again, these are split-second decisions being made, and I think that's kind of where all I can do for that answer, because I don't think an officer is thinking about, oh, well, what is the case law? What is the least intrusive thing I can do? And also, there is no case law on this, right? Like, there is no law that says, well, there's a frisk, and then the next intrusive thing is manipulating, and then the next intrusive thing is going into the pocket. And that kind of goes to the point that Justice Baer was talking about, his question to Mr. Rausch. So if we're looking at a line to be drawn, when we're no longer looking at objective reasonableness and starting to look at probable cause, that line isn't outside of the pocket versus inside of the pocket. That line is the scope of Terry. So putting it another way, as Justice Donahue was saying, was the removal of the object within that limited scope of what was necessary to discover and remove weapons.
Counsel, we can't write to say, well, if there's a less intrusive way to do it, but at the moment you don't really think about it, then that's okay. I mean, I understand what your case is, but when we're writing so that police officers know going forward what the appropriate approach is in this Commonwealth.
This is Justice Doherty. I have a quick question. A collaboration as to what Justice Weck and Justice Donahue are articulating. I would say it's fair to assume that the word manipulation triggers the plaintiff's guilty, as opposed to an extension of Terry. So as we talk about, my concern would be that it's a step above intrusion into the pocket, but the moment you say manipulation, an average officer on the streets of Philadelphia or anywhere will think plain field. What do you believe the Commonwealth's position as to the articulable standard that we should have, since this is an untouched area?
So the articulable standard, again, so for this case, let's use this case as an example. What else could the officer have done except describe the scene in detail, describe what he felt, and describe what was pulled out? Mr. says there was no articulable facts. He just said, I don't know, but there are articulable facts. He said it was large. He said it was hard. He described it as a cough syrup bottle in hindsight. So the question is, would it be objectively reasonable for that object felt through clothing for there to be a concern that it's a weapon? And I think the answer is yes. That object could very easily be consistent with plenty of weapons, and it's not consistent with 9 objects.
Again, it's Justice Fair, but your argument, the polar opposite of your adversary found, so it's easy. You say the standard's reasonable suspicion, and he says probable cause.
Yes.
And that's the case. And then it's up to the trial court and reviewing court. Did your police officer, after the outer search, have reasonable suspicion to go through? Yes or no?
Yes, have reasonable suspicion so long as we're acting within this limited scope of Terry. If the officer pats down and says this definitely is not a weapon, we're no longer talking about Terry, we're no longer talking about reasonable suspicion. That's out of the scope.
But even if, just to follow up on Justice Baer's question, counsel, even if it's reasonable suspicion, and even if Mr. Roush's point is incorrect on probable cause for Terry, you still have to hew to that least restrictive means line. Otherwise, you've collapsed the distinction between the whole Terry line of cases and a search incident to arrest. I mean, then it's just search incident to arrest. You have no more distinction, right?
Yeah, and the least restrictive means for when you feel an object that you can't immediately tell is not defined by any law. But again, I would say that removing the object is probably the swiftest and easiest way to confirm or dispel your reasonable safety concerns, especially given the fact that, again, manipulation can only do so much for one, and also this is a time-sensitive pressure decision on behalf of the officer.
Okay, thank you.
Thank you.
Both of you. We'll take a brief break and call the last case of the day.
Thank you, Your Honor.
The next argument is James and Tammy Leadbitter versus the St. Clair Hospital. Representing St. Clair Hospital is Mr. John Conti. Representing the Leadbitters is Miss Elizabeth L. Jenkins.
Good afternoon. In this medical negligence case, plaintiff sought discovery of certain background information concerning the surgeon who performed the disputed procedures. The surgeon was on the medical staff of St. Clair Hospital and maintained orthopedic surgery clinical privileges there. The issue relates to whether the hospital is protected from having to disclose a certain aspect of the surgeon's credentialing file. The hospital claims protection under the Peer Review Protection Act, as well as the Federal Health Care Quality Improvement Act, both of which are designed to foster candid peer review in relation to medical practitioner. Mr. Conti?
Thank you, Your Honor. May it please the court. John Conti for St. Clair Hospital. This court's decision in Reginelli has been wrongly interpreted to categorically deprive all documents residing within a credentials file of any privilege. In fact, in practice, credentials committees perform two distinct but interrelated functions, one of which is quintessential peer review. To invoke the nomenclature of Reginelli, a credentials committee functions as both a review committee and a review organization. Let me briefly describe the two interrelated functions. The first, which is not peer review, may be termed credentialing per se, and this involves a considered review or verification of documentary material relating to education, training, experience, licensure, research, etc. The second function, which is peer review, may be termed privileging, and this is a complex qualitative determination. Privileging determines the scope of procedures that a physician will be permitted to perform within a hospital. It determines the delineation of those particular procedures, be they surgical or otherwise, that a physician will be permitted to perform within the hospital's walls. And privileging requires an ongoing assessment of the quality and efficiency of care. It's a performance assessment. It may expand or constrict at any given time the permissible procedures a physician may perform.
Mr. Conti, Justice Barron, I apologize to you because I'm interrupting your beginning, but a couple of terms got by me. Are we talking, and I appreciate everything you're saying, are we talking about a review organization or a review committee, or both?
Your Honor, the Reginelli decision drew a distinction between review committees and review organizations and held that a credentials committee cannot be doing peer review because it's only a review organization. That, in our view, was dicta because that issue was not briefed nor argued, and the court therefore didn't have the record on which to see that a credentials committee also functions in a peer review capacity, which would, if you wanted to adopt the nomenclature of Reginelli, make it also a review committee.
Counsel, this is Justice Donahue. You've taken the position that this court's majority opinion in Reginelli was dicta on the functioning of a credentialing committee. I take exception to that only from the perspective that the entire Reginelli decision, at least this aspect of it, was based upon an analysis of the statutory definition of review organizations, which was comprised of two paragraphs, one dealing with peer review and the other not. So I'm struggling as to how that holding can be viewed as dicta.
Your Honor, to the extent that opinion is taken to hold that a credentials committee can function only as a review organization, and everything within a credentials committee file is stripped of any privilege, that would be an improper interpretation of that opinion. So we have endeavored to respect and adhere to what we believe is a proper reading of Reginelli insofar as it mentions credentialing, which is only to say that credentialing per se, which is an assessment of qualifications and activities, is not protected under peer review. However, logically and essentially, credentials committees also, by definition, have to perform a qualitative assessment, a performance assessment of appointees to the medical staff on an ongoing basis. And that is by definition, quintessential peer review.
Okay, let me probe that with you for a moment, Mr. Conti, because in this case, as in Reginelli, the precise same argument is being made. The phrase peer review functions is sort of a generic, all-encompassing kind of process that involves an evaluation of healthcare providers. But that's not what peer review is. Peer review is an evaluation of services rendered or ordered by a healthcare provider. And then more importantly, let me just take this to its logical extent. The privilege only applies in a civil action involving matters that were the subject of that peer review, i.e. services rendered or ordered. And so this notion that anyone's comment about the qualifications, expertise, et cetera, of a physician somehow fits this notion of peer review is belied by the fact of what we're really here about, which is the privilege, correct? I mean, we aren't really here about peer review. We're here about what can be discovered from the files of a healthcare provider. So I keep getting back to my point. The whole notion that the analysis of review organizations was somehow dicta as it related to credentialing, I'm sort of at a loss as to how we get there, considering, and this is my final point, credentialing can be done not only by committees, it can be done by a hospital board, individuals, or a committee. And so there's a disconnect between peer review committees and the second paragraph of review organizations that deals with credentialing.
Your Honor, I must respectfully disagree. No court in the United States that has examined this issue has found that the work of credentials committees are deprived of any privilege. Every court that's examined the issue has found that the workings of a credentials committee, as they actually occur, are protected in whole or in part. And plaintiff has cited not one case that stands for the proposition that they are advocating in this case. This is an extraordinarily important decision for this court and for healthcare practitioners around this Commonwealth, because credentials committees perform an essential gatekeeping function, determining who will be on the medical staff and what they will be permitted to do. And there is no committee that's more instrumental in protecting patient safety than the Credentials Committee in its privileging function. Peer review protection is a creature of the legislature. The legislature made the judgment that it needed to be done in order to enhance patient safety. And the only way it could be enhanced is by affording broad protection, because it is common sense and it is common experience. No professional is going to engage in a voluntary critique of his or her colleague, especially in the close-knit setting of some hospitals, if that critique of their performance is going to be the impetus for a lawsuit, if that's going to be Exhibit A in a claim against the hospital, peer review is coextensive with and exists only because of the privilege. If you have eliminated the privilege, you have eliminated meaningful peer review. And what the plaintiff will get in this case is a victory that I would term both Pyrrhic and ephemeral. It's Pyrrhic because it will come at great cost to the health and well-being of the patients of this Commonwealth. And it is ephemeral because it will be fleeting. You will have given the plaintiffs the keys to an empty safe.
Are you asking us to overrule Reginelli, Mr. Conti? Because we decided it like 2 years ago.
I am not asking the court at all to overrule Reginelli. As I said, in our brief, you will find nothing that suggests that Reginelli was wrongly decided, but more in line with Justice Weck's concurrence in the rejection of the petition for allowance of appeal in CRAPA, where there was an articulation of the view that there's an interrelationship between what a credentials committee does in terms of privileging and what it does, credentialing and what it does in terms of privileging that causes the appellants in this case, healthcare providers around the state, to say there must be a recognition of reality. And I say that by making the point that it is essential that this committee performs this function, because privileging, deciding what physicians can do within a hospital, whether it's a neurosurgeon or a transplant surgeon or orthopedic surgeon, necessarily subsumes, it incorporates an evaluation of the credentialing material. That's why it's done this way.
Mr. Conti, this is Justice Doherty, if I may.
Yes, sir.
With regard to your analysis, where are you focusing? The type of group that reviews the professional evaluations or the document themselves?
Your Honor, we have looked at both who is conducting the peer review, under whose auspices it is, and the nature of the documents. And I would point out, as the court is well aware, that the documents at issue in this case, which are 17 pages that we withheld, 141 pages we produced, have been acknowledged by the Superior Court to be peer reviewed. And there were issues related to that judgment that were proffered to this court, the court did not accept. So for the purpose of this argument, it is my assumption that it is being acknowledged that the documents in question are proper peer review. They just happen to reside and were conducted or developed under the auspices of the Credentials Committee. And so I'm not, Your Honor, to answer you directly, focusing on any particular aspect of those documents. They are performance reviews, they are qualitative assessments which meet the statutory definition of peer review, and which, frankly, if they are to become exhibits in civil litigation, will cease to become meaningful.
Mr. Conti, you certainly wouldn't object, would you, if court's consideration of this case leads it to reverse Reginelli, would you?
I'm sorry, Your Honor?
Can you hear me? Can you hear me?
I can.
You certainly would not object, would you, if this court's consideration of this case leads the court to reverse Reginelli, overrule Reginelli, would you?
I would not, because Reginelli, in my view, brought to bear an overly restrictive view of this privilege. And the peer review privilege, unlike the statutory privilege or unlike the privilege for marital relations or for attorney-client privilege, it is substantively and qualitatively different. The privilege only exists to protect the information that is generated by it. As stated another way, if this court restricted the marital privilege, spouses would not necessarily stop or restrict talking to one another. The same with the attorney-client privilege. That wouldn't necessarily cause a great restriction on the communication. But here, the two are coextensive, and this court took the view that this was in derogation of the truth, and therefore the privilege should be very narrowly viewed. Well, the truth, if you will, as I said, the documents that they seek only exist because of the privilege. They would cease to exist if the privilege disappears.
Mr. Conti, Justice Baer, I just want to make sure I have things straight initially. Credentialing committee decides who gets to be on staff at a hospital. Is that correct?
Yes, sir.
And a privileging committee gets to decide among hospital staff who gets to do neurosurgery and who gets to do spinal surgery and who gets to do other surgery.
It's the same committee. It's denominated a credentials committee. They serve two functions that are interrelated. And I can point you to a phrase when you're finished, Your Honor, that will explain why the two are so woven together.
Well, actually, you just answered one of my questions. In my mind's eye, I had two committees functioning independently. It's one committee that does both. Is it possible that that committee has within, well, I think it is possible, you gave 100 and some pages and withheld 17, that committee that does credentialing and privileges has within its files both peer review and non-peer review documents?
Yes, Your Honor.
And is it your view then that to the extent it's peer review, and a judge can look at it in camera to determine this, it's not discoverable regardless of what you call the committee, et cetera, et cetera? And if it's not peer review, it is discoverable.
Absolutely. That's exactly our position.
All right. I think, and I have to go back and read Reginelli very carefully. It was a very finely written, long opinion. But it seems to me off the top of my head that it's factually distinguishable. It involved, if memory serves me correctly, a private company staffing an emergency room and one individual within that private company keeping some files. And that seems to me to be factually pretty far from where we are now, where we have a credentialing, privileging committee of a hospital gathering peer review. So I'm not sure that, with respect to my colleagues, and again, I haven't studied this, I don't know that anything needs to be reviewed or even legally distinguished. I just don't think they're the same cases. All cases are decided against their facts.
You could certainly read Reginelli based on the issues that were accepted on appeal to be predicated on a set of facts that is entirely different and distinct from what is here.
Now, does that create a mess of the law because all of a sudden you have two criteria going depending upon the facts? I'll figure it out. That's rhetorical.
To answer your question, Your Honor, I think the case, as postured before the court right now, only requires the court to hold that a credentials committee can conduct peer review, and if it holds that, then the documents which are at issue would be cloaked with a privilege, and that would be the end of it. Again, the Superior Court found that to be the case. If I could...
Counsel, could you just clarify that for me? Did you just say that the credentialing committee conducted peer review, or that the documents in their files were documents that were created and produced by a peer review committee?
The peer review is conducted by the committee under the auspices.
What committee? What committee?
The credentialing committee.
So you have a credentialing committee that is conducting peer review.
The name of the committee, Your Honor, the title of the committee is the Credentials Committee. It performs two distinct but related functions. One is credentialing, one is privileging. Privileging in the qualitative analysis is peer review. Yes, it performs peer review by eliciting the documents, the performance assessments, the references, etc.
From the peer committee?
Sorry?
Are they accessing documents that were produced and created by the peer review committee? Mr. Conti, the definition of peer review in the statute lists 11 different committees that are included in the term peer review committee, and a credentialing committee is not one of them. I mean, so if what you're telling us is, and frankly, this is why I thought we accepted this case, somehow documents that were proceedings and records of a peer review committee found their way into the credentialing committee file. And then the question then becomes whether or not those peer review committee documents now housed in the credentialing committee are privileged pursuant to the statute, privileging proceedings and records of a review committee.
Your Honor, I must say that that is a hyper-technical view that relies on the nomenclature and does not take a practical look at how peer review or credentialing is done. And I go back to the point that it is a position that no other court in the country has accepted. I wish there was another way to do it, but the fact is, over the past half century, as hospitals have become increasingly regulated by the Joint Commission, by Medicare, by the State Board of Health, they've had to comply with a patchwork of regulations, including conducting peer review of doctors applying for privileges. So this is the natural evolution of how that occurred. It is perfectly consonant with the spirit and the letter of the Peer Review Act, and I ask the court to respect that. I'd like to read, well, I don't mean to interrupt you.
Can I just point out one thing before you go on, Mr. Conte? The issue that we accepted for review states whether the Superior Court erred by ordering the production of acknowledged peer review documents solely because they were maintained in a physician's credentialing file. Not that they were created by the credential, but they were maintained in the credentialing file. So, I mean, if what you were talking about is documents that were created by a peer review committee and found their way into a credentialing file, which is the case that I thought we were looking at, that's one thing. But now, as I understand your argument, you're saying that it was actually the credentialing committee who created these documents, not that they were created by a peer review committee as defined in Reginelli.
Your Honor, that unfortunately is confusing to me. What the credentialing committee does is gather information. So this information gathering is under the auspices, under the direction, under the management of the credentialing committee. One of the categories of documents they gather are these OPPEs, these ongoing professional performance assessments. They elicit those, they solicit those. They solicit performance references from other physicians. That's how the committee functions. The credentials committee doesn't stand up in mass, leave the room, and go into an operating room and conduct peer review. They have proceedings. They receive documents. That's how they conduct their peer review. And it is absolutely crucial that this court understand that physicians, when you apply for privileges and are granted an appointment, you're not just given a blanket appointment, you are given an appointment to act in accordance with your privileges. I will read for you one sentence, if I may be indulged, page 286 of the reproduced record. This is Dr. Petraglia's acknowledgement that he's been appointed or he's requested privileges. The form reads, and I'll just read one sentence, I have requested only those privileges for which by education, training, current experience, and demonstrated performance, I am qualified to perform. Now, nothing, that's the end of the part of the sentence, nothing better illustrates that it is an inextricable, woven burden that the committee has to integrate credentials and performance assessments before they can grant privileges, which is really what permission the physician has to provide care to the patient. It's the way it's done in every credentials committee that I know of and around the country, Your Honor, and I apologize if it doesn't have the clarity to fit within the definitions necessarily the act. I think it does, but I mean, the statute's been around for a half century, and the demands placed on hospitals by regulatory agencies, by governmental agencies, accrediting agencies have been piled on in a patchwork fashion. And the hospitals, and I think, do an excellent job struggling so that we all understand when a patient goes into a hospital now, because of ostensible agency and corporate liability, the hospital's responsible for those doctors. So they have every incentive to make certain that the doctors are properly credentialed. And there is nothing more important in terms of providing quality, safe care for patients than the work of the Credentials Committee. And it would be a great
Mr. Conti, you're about to wrap up and sit down. It's Justice Babb. Before you do that, Reganelli discussed distinctions between a review organization and a review committee. Do you want to comment on that at all? Do you see any distinction? Does it make any difference to you whether or not your peer review material is in one or the other, or are they even discrete?
I do not, Your Honor. I mean, I respect the court's opinion. I think that was a technical distinction that relied too much on the labeling and deviated too much from the spirit of the Peer Review Act and could have been more accommodating. And the necessity of the courts confronting this important issue, I think, demonstrates that how that could have been come out differently.
Just on that point, counsel, you know, I don't disagree with you that maybe since 1974, the pressures on hospitals and healthcare providers in general have changed dramatically, and the dynamics may be different. And, you know, that may call for a amendment to the Peer Review Act. But, you know, when the legislature used the term peer review organizations and defined it, they actually used that phrase in another section of the act where they extended immunities to individuals who participate in review organizations, a much broader grant of immunity than what the privilege is for peer review committees. So, I mean, it's not like that term, you know, sort of came out of the blue and then they never again referred to it in the act. They had something in mind when they defined peer review organizations versus committees. So, you know, it's a phrase that has its place and purpose within the Peer Review Act.
But isn't it the obligation of all of us to understand that in the half century, as medicine has evolved and the role and responsibilities of hospitals have evolved, that there could be some accommodation to the spirit of the Peer Review Act, which again, at bottom is patient safety. Everyone has the same end in mind. And it's simply our view that the best way to arrive at that end of patient safety is to accord credentialing committees this limited protection.
Thank you.
Mr. Conte, as Justice Babb said, we're going to conclude this argument, and this may be a particularly stupid question, but does St. Clair have a peer review committee out there?
Your Honor, they have a number of committees that function in a peer review capacity. Yes, they do. But because
I know, but is there a committee out there called peer review to do peer review?
Yes, there are any number of committees that are charged in part with peer review responsibilities. The complexity of medicine, Your Honor, is not such that there can be one peer review committee that addresses every aspect of quality of assurance or quality of care. And if I may just say this, the definition of a peer review committee that's in the Act is it's a committee conducting peer review. And so the fact is, when various committees of the hospital are engaged in the review of the quality and efficiency of care, which they are mandated to do in certain respects. In that capacity, when they're doing that, they are peer review committees. But the notion that there's one singular peer review committee that handles all quality and efficiency for all of the hospitals, various departments, physicians, the answer to that is no. No hospital has that.
Thank you very much. Any other question? Okay.
Can I just ask, and this is on the second issue.
Yeah.
As I understand your position, the trial court and the superior court just got it straight out wrong what your claim of privilege was regarding the National Data Bank information. Your claim of privilege was pursuant to the federal act, totally separate and distinct from the Peer Review Act. Am I correct in that?
You are correct. It's not a peer review privilege that we're involved
So they
in.
just straight out misunderstood the application of the lack of application of the Peer Review Act in that context, because you were claiming the very clear privilege for those responses to requests to data bank inquiries as the basis for withholding that information.
That is correct.
Okay, thank you.
Thank you. Ms. Jenkins.
Good afternoon, Justices. Thank you for the opportunity. My name is Elizabeth Jenkins. I'm here on behalf of Tammy and James Leadbitter. And I want to begin with the fact that there are no documents within the credentialing file of Dr. Petraglia that St. Clair has claimed are the proceedings and records generated by a peer review committee. That which has been redacted are the identities of the authors of the letters of recommendation from Dr. Petraglia's fellowship, I assume, because I haven't seen them. But there's nothing there's no claim that a peer review committee generated documents that just so happen to be in the file, the credentialing file. These are credentialing documents that St. Clair now wants to be protected by the peer review protection, which...
Ms. Jenkins, Justice Baer, can I just specify, were these documents ever provided to the trial judge to review in camera to decide if in her or his judgment they were peer review or not?
No, the defendant never requested that.
So if we reverse and send the case back down, that would be the logical step. In other words, there's a question of, as a matter of law, what is and is not peer review and what is and is not protected, again, as a matter of law. And then there's always the subsidiary question of whether or not these documents are reasonably peer review or not, as the statute defines, and that's up to the trial court.
It is up to the trial court. However, there's been no claim that these are peer review documents. They're claiming now that a credentialing committee can conduct a peer review, but that's not what these documents are. So what St. Clair wants this court to do is essentially overrule the third ruling in Reginelli, wherein it says that credentialing committees are not subject to the protections of peer review.
So Ms. Jenkins, could I jump in there?
Yes,
so it's your view that the best interpretation that we can give the statute, and in fact, the only review we can give the statute, is to vindicate whatever label the healthcare institution has put on this particular entity rather than the work the committee or entity is doing.
No, that's not. I'm sorry. I didn't mean to interrupt you.
In other words, the label controls, not the substance. Is that right?
No, I don't think that's. I'm sorry if I wasn't articulating it clearly. A peer review is a targeted investigation into care and treatment that has been ordered or rendered by a physician within the hospital, and there's been no claim of any of that. In fact, by the descriptions in the privilege log, these are letters of recommendations from physicians, presumably in Maryland, because Dr. Petraglia never practiced in Pennsylvania before the dates of these. And these are ongoing metrics that are required by JACO. So to your point in your memorandum with the CRAPA decision, yes, it may be. They may make a mistake at some point and put a peer review report inside of a credentialing file, but that didn't happen here. And in fact, all the parties in this case agree that there was a peer review that was done with respect to my client, Mr. Leadbitter. That report's not in there. The results are, and St. Clair didn't withhold those. So what happened is the results are that Dr. Petraglia voluntarily reduced his privileges and would not do surgeries in certain ways. And that is, I assume, is in response to the peer review that was conducted, because there's no report of that in the file, though it's been claimed that they've withheld that document from me. So yes, it's possible for hospitals to make mistakes and place the proceedings and records of a review committee, a report of a peer review committee in a file, but that's just not what we have in this case.
Counsel, this is Justice Doherty. I'd like to tease out a question with regard to what Justice Weck just asked you as to the type of material. Page 15 of Mr. Conti's brief, he indicates under B, one document entitled Professional Peer Review Reference in Competency Evaluation containing performance evaluations to Dr. Petraglia by physicians was withheld. How are you arguing? I'm confused. You said that there were no documents to be considered a peer review, yet this caption specifically says that.
Well, Justice Doherty, it is a label that was placed on those documents by St. Clair Hospital. My understanding from reviewing the application by Dr. Petraglia and the context of these withheld documents, as well as Mr. Conti's argument before the Superior Court, that these are letters of recommendation that were sent to him by the references that were redacted from Dr. Petraglia's application for privileges. So my understanding, just from teasing out what the context clues, is that these are letters of recommendation that come from physicians, presumably in Maryland, since he had never practiced in Pennsylvania. So because it has a label doesn't make it the records and proceedings of the peer review committee.
Thank you.
Counsel, do you have a position on the national data bank privilege that was claimed here? Because it appears to me, from what I've read of the opinions and the briefs, that there was a misunderstanding by Judge Hershberger, the trial court judge, and the Superior Court as to what privilege was being claimed as to those responses to inquiries.
My understanding is that there was no privilege claimed at all, that simply St. Clair has claimed that they're confidential, that the federal act precludes them from producing them in discovery, where there are several places within the federal law that says state law overrides what we're saying. There should be nothing in this that precludes the production of these if state law provides that. The rules of discovery, anything that is not privileged and is relevant should be produced, and therefore, based on 4003, they should be produced. But in addition, regionality also supports the fact that non-privileged documents should be produced.
But you would agree with the proposition, and I'm relying on Mr. Conti's brief for this, that if we agree that under the clear terms of the Federal Healthcare Quality Assurance Act, that the response to inquiries from the data bank are to be held confidential, then regardless of what the Peer Review Act in Pennsylvania says, that federal statute is going to trump in that situation.
But the federal statute makes exception for parties producing things in producing these documents. It's in the confidentiality section of 42 USCA 11137B1 has a portion of it that says nothing in this subsection shall prevent the disclosure of such information by a party which is otherwise authorized under applicable state law to make such a disclosure. Also in 42 USCA 11115D, it talks about the treatment of malpractice claims, and there's nothing should preclude a plaintiff from pursuing her claim. There's also under the HCQIA also states that nothing in the subsection shall prevent the disclosure of such information by a party which is otherwise authorized under applicable state law. So there are several places within the federal statutes which state that under applicable state law that these documents can be produced by a party. And St. Clair, a party of this case, is in possession of these documents.
Let me ask you, Ms. Jenkins, on that, if I may briefly. Would the fact that under your interpretation, then the Reginelli rule would basically gut the under that interpretation would gut the federal law? Does that argue for a revisiting or reinterpretation of the Reginelli holding?
I don't think it would, because the HCQIA, the data bank, was part and parcel of the credentialing file, and that it's used purely for credentialing purposes. And there's no dispute that that's the reason it's used. I think the law is clear. I don't think that state law regarding the disclosure of this by a party, I don't think it needs to be revisited.
So it's going to be a new holding here where, if I understand you, that Pennsylvania is going to be the only state saying data bank reports are discoverable, notwithstanding the supremacy clause and federal law.
I don't know that Pennsylvania is the only state that says the data bank information is discoverable or should be produced. I do believe that it under CRAPA and under Reginelli, I think data bank materials were produced because they were part of the credentialing file. This is the first case that it's been teased out and made a separate issue, but I don't think that it's the first case in which such information has been produced.
Ms. Jenkins, Justice Babb, the Superior Court wrote that this information in dispute is peer review information. Do you agree with that or disagree with that?
Well, I agree that the Superior Court made a conclusion that these seem to be peer review materials, but they did what the Superior Court did not do was take the steps to then go through what is protected by the confidentiality clause within the Peer Review Act. And that's that the clause specifically states what is and isn't protected. And
what is the clause? I have the Peer Review Act here. You can tell me your site.
Sure. The section is, get my glasses, I apologize, 425.4. That's the evidentiary privilege that's created by the statute.
I think I have it. Do you agree? Let's assume that our court, we decide that this is peer review material. That doesn't end the inquiry. We then have to go to that section of the section of the statute and see if it's confidential or not. Is that correct?
I think that they have to be read together for it to be peer review material. I think the Superior Court didn't take the steps to determine whether or not it truly was peer review protected material, or because there were no inquiries and there was nothing that except labels in the privilege log that would indicate that it came from a peer review committee or a committee performing peer review. And St. Clair has never asserted that there was ever a peer review committee. So it wasn't peer review material.
He just told us that their credentialing committee and their peer review committee are one. And then he said they have multiple committees like this because we all appreciate the micro complexity of medicine. I mean, even within spinal surgery, there's 5 different subspecialties. In neurosurgery, there's 5. Somebody does cancer and somebody does benign and somebody does frontal lobe and somebody does rear lobe. So it's entirely understandable how a big hospital or any hospital has multiple committees engaged in credentialing and privileging. So it seems, at least to me, attractive to get down to the substance of whether this material, in accord with our statute, is peer review or not. And if it's peer review protected under our statute, then the courts should protect it. And if it's not, it's not. And that sort of, and that may, and I'm not, again, I think Reginelli is factually distinguishable, but I don't care. I don't think I care, but I'm asking for your opinion. If it's in a committee, if it's in an organization, it's in a committee that does the only credentialing or only privileges, or a committee that does both. I'm a pragmatic guy by nature, as everybody knows. want to get into, is this or is this not under Pennsylvania law peer review? Am I wildly off base?
You're not wildly off base, Your Honor, but I think that there have to be steps taken, and it has to be an investigation into care and treatment that's ordered and tracked with the statute. So, and there's not been a claim to that. It's basically been a claim that the credentialing committee can operate in secrecy, and I don't understand why the secrecy has to be there. Either he's qualified or he's not, and there's not necessarily a need for frank discussion when you're requesting a letter of recommendation from his fellowship.
Counsel, you said earlier that you know from a discovery production in this case that there was indeed a bona fide peer review of the services rendered and ordered in your client's case. Am I correct in that?
Yes, Your Honor.
And you didn't get the records or proceedings, but you know what the result was. Where did that come from? Did that come from where? The credentialing file, or where did that come from?
So in all the depositions I've taken and in all of the responses to interrogatories, everyone has said there was a peer review done with respect to James Leadbitter. So, and in their responses to interrogatories, they said that, they objected to the production of it and that they were withholding documents because a peer review was performed. And you
don't disagree with that, is that right, counsel? You don't disagree with that? Those documents could be withheld pursuant to the privilege.
I don't disagree with that, and I didn't raise that issue.
Okay, because that was a review of the services rendered and ordered in this case.
Correct. That was that's a separate issue, wasn't within the credentialing file, and I didn't ask that be produced. I mean, I asked to be produced initially, but that's not the issue that's on review now. If you look at the reproduced record, and I will. Okay, if you look at the reproduced record at pages R265A and R266A, there is a memorandum note to file by one of the privileging committee members, which delineates the changes that were being made to Dr. Petraglia's privileges following Mr. Leadbitter's procedure. And that was placed in the file, and that's just, and by results, I meant what happened as so far as his credentials were concerned. I don't know what the conclusions were of the physicians who reviewed him. I don't know what the proceedings and recordings of that are. And if there was a report, it was indicated by St. Clair it was withheld. I don't know what that says, but I think a balance can be struck between credentialing and between peer review, in that they can conduct a peer review. They can, with respect to specific care and treatment. And I think that physicians who participated or experts that they want to speak with about the care that was rendered can come in and frankly discuss the issues and what they think went wrong or didn't go wrong. And that doesn't have to be placed in the credentialing file. And here it wasn't. It was just the changes to his credentials and privileges at that time.
Okay.
But that would be peer review, right?
The contents of the report with respect to my client? Yes, Your Honor.
Yeah,
Yes.
if somebody comes in and says, hypothetically, that this doctor committed medical malpractice on your client, we all understand why the hospital needs to know that because of subsequent clients. But you don't get that to use as a smoking gun in the med-mal case.
Exactly, and I think that is the purpose of the peer review statute, to protect that exact information.
Exactly.
That, from my view,
I think we've explored this in pretty fair detail, so unless there's questions, we're going to conclude the argument. Thank you.
Thank you.
Thank you.
thank you both. Good job, tough case.
Thank you.